Hello, everyone. Thank you for joining the webinar, and we apologize for the late start. We had a few technical difficulties, but we're ready to jump in. This is a Hyperproof presentation on privacy considerations for bringing employees safely back into physical workplaces. Thanks for joining us. This webinar is being recorded, and we will have time at the end for live Q&A with our featured speakers. And with that, let's get started. I'd like to turn it over to Craig Unger, who is a Hyperproof CEO and founder, to introduce himself and our guest speaker.
Thanks very much, JC, and welcome everybody to today's webinar. In today's webinar, we're going to be discussing how to get employees safely back into physical workspaces surrounding, your privacy considerations and other compliance considerations. Quick note about me, I'm Craig Unger, and I'm the CEO and founder of Hyperproof.io, and we are a company that works in the compliance space, and we have a number of compliance programs as part of our product offering. Today, we're very happy to have with us Julie Glover, and Julie is a longtime privacy expert with her company 6 Degrees Privacy Consulting. And perhaps, Julie, I'll have you introduce yourself.
Thank you, Craig, and thank you, JC. Welcome, everyone. I am, as Craig mentioned, an independent privacy consultant. I run my own business, 6 Degrees Privacy Consulting, and I work with a number of different companies in all different sectors, helping them build their privacy programs out and comply with privacy regulations globally, privacy by design work as they're building new products and services, etc. So I'm really happy to be here today to talk about this very relevant topic.
Super. Thanks very much, Julie. Okay, well, why don't we get started? So what we've set up here is a set of questions to guide us through the discussion with Julie. And why don't we dive right in since we got a little bit of a late start here. So, Julie, could you give us an overview of the key U.S. and EU privacy regulations that really govern privacy in the workplace?
Certainly. There are a number that I won't be mentioning. There are various state and local regulations. Many states are still trying to pass their own individual privacy laws because in the U.S. we currently do not have an overarching federal privacy law. They've been talking about it in Washington for a number of years, and it still has not passed, and we're hoping for it eventually. But there are a couple of really important regulations, one in the U.S. right now that became effective in 2018. It's the California Consumer Privacy Act, or the CCPA. You might have read about it. And the other one is an EU privacy regulation called the GDPR, which is the General Privacy Regulation in the EU countries. And both of those are very comprehensive privacy laws that govern businesses and their use of individual private data, but they also cover the use of employee or contractor data in the workplace. So I would say the CCPA and the EU GDPR are the two main privacy regulations that most of us are concerned about right now.
One question, Julie. I know that, in our state here, Washington, they're looking at also passing kind of a variant of the CCPA. Can you just give us a quick overview of what's going on in individual states right now because I guess in our case, the federal government hasn't contemplated the equivalent of the GDPR, so it's kind of at the state level.
Yes, that's right, Craig. And there are, like I mentioned, a number of states that are now trying to pass their own individual privacy laws. Washington State is one of them. Oregon, where I'm based, is also another, but there are many others. What we're seeing right now is many of those states are working on drafts that emulate either the GDPR or the CCPA and incorporate many of the requirements of both of those laws, and many times also add additional requirements that are specific to their states. So you can see how if we end up with 50 different privacy laws in the U.S. for the 50 states, it will be a patchwork of trying to comply with all those different regulations.
I know, yes, it seems like it's going to be really interesting times ahead for U.S. companies trying to comply. Well, thanks for that, Julie. Let's go on to the next question, which I think is probably top of everybody's mind, which is, we're living in the COVID-19 era, and, how do we think about keeping employees, safe during this time in terms of keeping them safe in physical workspaces and also doing kind of what you need to as a company?
And many of you on the line might be HR professionals or in charge of compliance within your companies. And these questions are being batted around by many business people at this time. Obviously, trying to get ready to bring your employees back to a safe workplace with COVID is a very large issue with many moving parts. But one thing to keep in mind additionally is that as you bring them back, you might be thinking about doing body temperature checks. You might be thinking about asking them to fill out surveys about have they traveled, have they been ill, those kinds of things before you allow your employees to come into the workplace every day. This is very sensitive personal data, not only under the two regulations that I mentioned, the GDPR and CCPA, but under just about any privacy law or privacy framework that you might be working within. So, HIPAA is another one. You think about health data, and generally HIPAA doesn't apply to employers. But thinking of all the privacy regulations out there as you consider what kind of data you're going to collect to make sure that your workplace is safe for your employees, for your staff, for your visitors. It's very important to think about privacy. Especially under the GDPR, the kind of data you might be collecting, especially related to health, temperature checks, and those types of things are considered to be very sensitive data. They call it special categories of data under the GDPR. And if you are a workplace or have an office in the EU, you will need to know that you need an affirmative written consent from your employees and visitors to collect that kind of information before you do so. You'll also need to have, I would recommend, a separate privacy notice that's transparent about what kind of personal data you'll be collecting in the COVID context to bring people into the workplace. The other thing to think about with the CCPA, oh, go ahead.
Well,
CCPA has some requirements too.
I was going to throw you a little bit of a curveball. I know that recently there's been some talk, and this is the difference between the EU and the US, where certain privacy laws might be suspended in the case of COVID-19. I'm just wondering, for the examples we're talking about here, things like taking a temperature, is that something that employers can do if they decide to do, or the affirmative consent concept in GDPR has an equivalent in the US and it requires consent both ways?
It is something that employers can do, but they need to do it the right way. Like I said, if they are talking about an office in the EU, they need to get that affirmative written consent prior to collecting that information. The CCPA did become enforced July 1 this year. They did not put that time frame off. They do have They are waiting to enforce the employer-employee part of the CCPA until January 1 next year. But caution there, because CCPA does have a one-year look-back provision, meaning that even though they might not be enforcing the employee data requirements under the CCPA right now, once they begin enforcing that next January, they can look back a year. So I'd say the overall answer to your question, Craig, is most of these regulations are not, if they've already been passed and they're in effect, they are not waiting until COVID is over, let's say, to be enforceable.
Got it, got it. And the questions that we've prepared here on the screen that you're recommending that organizations think through before collecting personal data, are these, I would imagine these are consistent with both the GDPR and CCPA, or can you talk a little bit more about how you came up with these questions?
Yeah, certainly. And I want to make clear that I'm trying to paint a picture of a broader privacy program and a privacy framework that you would be working with. Certainly CCPA, GDPR, other state regulations that might come into effect are important, but these are also just general privacy principles. And when you think about collecting the kind of personal data you might need to collect to bring people back to the workplace, it's really important to try to limit the amount of information, personal information that you collect. If you don't really need to collect temperature, as we all know from reading the news, many people may be asymptomatic. So is temperature really going to give you the information you need to decide whether to let somebody into the workplace? So try to minimize the amount of personal information you collect to what's really, really necessary for you to make good decisions. Also think about your own internal business policies. Are there confidentiality requirements around employee data that you might have in your employee handbook, or, you know, obviously in the regulations? You want to make sure if you're collecting that sensitive data that it is really only accessible by those in the workplace who have a need to know, for instance, those making the decisions, business unit leaders or HR, or security people, that kind of thing, and that it's not shared with others in the workplace. Also, once you've collected that information, the best practice would be, for example, take a temperature, do not retain that data, do not store that data at all. Take the temperature and then say yes or no. So those are some things that you want to make sure that you're thinking about overall as you put your policies together.
Super helpful, Julie. Thank you very much. And it's actually acts as a really good transition to the next question, which is, you know, I think we've all heard a lot about GDPR over the years, but it seems like it's kind of a big, you know, atomic iceberg of requirements that's hard to really kind of get into. But here, you know, we wanted to ask you a little bit about some of the specifics so we can dive in a little bit more. And I think it relates to what you were just talking about around things like retention and things like that. So the key principles are data minimization, purpose limitation, and storage limitation. Can you give us some more background as to how to think about these concepts and perhaps how to think about applying them as well?
Sure. And as I mentioned earlier, first of all, think about collecting the least amount of information you need to make good decisions about what's going to happen in your workplace. That's data minimization. Purpose limitation is about only using that data for the purposes that you gathered it for and not for other purposes. Just because you might have some health information you needed to collect in this situation about an employee, that doesn't mean that you should share it with a vendor for advertising purposes, or share it with others in the workplace who don't have a need to know that information. And storage limitation, store the data for the shortest amount of time that you absolutely need it, and if you don't need to store it at all, don't do so. Make sure that you're doing secure storage as well. And one other key principle that's not in here is transparency. I mentioned earlier recommending a specific COVID privacy notice that is transparent and tells those about whom you're going to collect this sensitive information, why you're collecting it, how you're going to use it, who it's going to be shared for, how long it's going to be retained, and those types of things.
Makes sense. I have a question on the storage limitation part that I want to ask you about. One of the things that, you know, I know as somebody who's running my own company and trying to assure that we're, you know, within, you know, the boundaries of what we're supposed to be doing, not just around the COVID piece, but around all the data we collect. On the storage limitation side, there's some limitations with the GDPR. There's also some U.S. laws around retention for the purposes of, you know, any like government inquiries and things like that. Can you just comment on like the balance there and how those two things balance out in your mind?
Yes, and I just would like to note that this is the kind of thing you should definitely be in touch with your lawyer about. There are this is obviously not legal advice, but there are legal requirements about data that needs to be kept in case there's a government inquiry of some type, or, for example, if your company is subject to litigation. There are litigation holds often on some data, and who knows, that some of this data might be subject to that. Normally what I've seen is that in privacy policies posted on business websites, for example, you'll see that they do have a caveat that they won't retain the data unless they need to retain it for legal or government purposes. So that's generally what I would say about that.
That's right. That's actually how we handled it here. Thanks for that, Julie. So let's diving a little bit deeper into the COVID side of things. You know, we've all heard a lot about contact tracing and how important that is in order to be able to actually keep the disease controlled to a certain degree. What are the top privacy issues that companies should be thinking about around contact tracing?
Contact tracing, I think, is an interesting beast, and I think that we're all learning more about it every day as the states put together their programs. And it probably is going to be different from state to state. But again, I would apply the general privacy principles we've already talked about. First of all, if you can do contact tracing, or if the state can do contact tracing without actually using GPS on people's phones, or within a workplace, for example, if you can avoid having to track employees and how close they're getting to each other as they walk down the halls or go to the cafeteria, if you can avoid using those things and you can get the information otherwise, I would recommend not using those kinds of technologies because they are very invasive and sensitive. If you need to use them, then you need to use them, but put the controls around them, again, that we talked about. Access restrictions, those just need to know. Data security, purpose only for the purpose of tracking for, COVID. Don't use it for performance management reasons, for example. Notice and transparency to the employees ahead of time about what you're doing and how you're doing it and why. And making sure that you're not sharing that information either internally or externally, except to the extent that it's absolutely needed.
I see. Got it. Okay. Well, we talked a little bit about, states, certainly CCPA is a state regulation and some other state regulations. I wanted to dive into that a little bit more carefully here and ask, are there particularly relevant state laws that apply, in these particular situations? Obviously, some of the regulatory requirements like CCPA, I know Florida has CIPP-A. What can you tell us about other states and what they're doing in these areas?
Well, there's one state law I'd like to point out in particular, and it's actually been in effect for quite some time. It's the Illinois Biometric Privacy Information Act. There are other states, many other states, who are working to put similar laws into place. I know Washington State and Texas are two that are two laws that I believe Texas is in place already. It's not as restrictive as the Illinois law, and other states are trying to do this. But if you look at the most restrictive so far, it's the Illinois Biometric Privacy Act. And this is if you are trying to make sure you're identifying people appropriately to bring them safely back into the workplace, and you might be doing things like retina scans, fingerprints, facial, hand scans, those kinds of things before they enter your workplace. You need to be really careful. And especially in the state of Illinois, but I think that these kinds of requirements are going to spread to many other states. You need to actually, in Illinois, get written consent prior to requiring these kinds of access controls for employees. So that's something to be aware of, and Again, as I mentioned, this one is the most restrictive right now, but I don't think it will be the last.
Yeah, and let's transition also, when you think about some of these, you have the Illinois Act, you have the one that we're talking about around CCPA and GDPR, and we've talked a little bit about how companies need to think about, those kinds of laws and putting in certain constraints on what they're doing. But let's transition to talk a little bit about what are some specifics that companies actually need to do, the specific things they need to do to protect personal data, the actions that they need to take?
There are many things that are part of a good privacy program overall, and those things definitely apply to any data like this that you are collecting as you consider bringing employees back to the workplace. But they also apply to any kind of personal data that you are collecting and processing, sharing with third-party vendors, HR vendors, benefits vendors, et cetera, in the workplace. So, and I feel like a little bit of a broken record here, but these are really important framework privacy issues to think about, no matter what kind of regulation you're trying to apply or where your business is located. And so access controls, again, to the extent you're collecting and retaining employee data, which of course most employers do, that data should be protected and not accessible by anyone in the workplace except for those who need to know it to do their jobs. HR, of course, needs to know much of that information, but if you're a large company and you have different parts of your HR department, perhaps only part, let's say the benefits department needs to know the benefits information, but maybe the employee relations group doesn't need to know that, so they don't need access for it. So having good roles and responsibilities documented for your HR people, for managers who might be accessing their employee data, that's very important. Secondly, privacy security training for staff. We're talking about COVID here in this webinar, but even aside from that, privacy and security training is very important, and you should be doing it annually to explain to your staff what your policies around privacy are, how they should be handling personal data, both of other employees and of your customers and clients, and those things should be documented and trained for new employees and then once a year for everyone. Vendor management is a very important part of a privacy program, meaning with what vendors are you sharing personal data of your employees, of your customers. You should have contracts in place with those vendors that provide for privacy and security terms that the vendors are responsible for, and making sure that you're not sharing more information with particular vendors than you need to. All of that should be documented in contracts. Fourthly, data retention and deletion policies are very important so that you're not retaining personal data longer than you need to, and that you have secure ways to delete that data, whether it be paper data or electronic data. Also, with respect to COVID, but again, with respect to all personal data that you're processing in your business, both employee and customer data, make sure you have the privacy notices and that they're very transparent and written in plain language as best you can. That really describes what kind of data you collect, how you use it, who it will be shared with, how long you'll retain it, and what the individuals whose data you're processing, what are their rights? Can they submit a complaint? How do they do that? How do they get access to that data? Can they ask you to delete their data? Those requirements are different under different regulations, but it's also really important to have a way that an individual can contact you. And then make sure that you're documenting all of these policies, whether COVID specific or not, and that you have those available for your employees, that you have strong procedures behind them, and so that employees understand, according to their own roles, how does it impact them. So those are several things that are a part of a strong privacy program.
Thanks, Galino. I want to key into the last one around documenting. I think what I've seen in the last number of years as we've done, a whole lot more of our own compliance, both here at Hyperproof and even in companies that where I worked in before, is, one of the challenges that regulators and auditors want to see is that things are properly documented, and also that the organization is set up from a process perspective to actually be able to run some of these processes in a way that's faithful to the design of them. Sometimes this takes the form of like an information security team, or it's in HR doing training, as you said, but they're very keyed into how you're approaching the problem, in addition to just testing the results of the policies. So it's an interesting transition, to the next question, which is well-meaning organizations, they want to do these things. They've set aside some resources to make sure that they can make these policies, happen and support them. But what are the ways that we should think about in terms of how we organize for this? How should teams be working together? Who are the important teams? And how do we ensure that we're working across the organization to make sure that we have, these policies in place?
That's an excellent question. Thank you, Craig. One thing I would really like to emphasize, and I know this can be difficult sometimes as you're starting to build a privacy program, but it's really important to think of a couple things. One is that privacy can really be an economic advantage. You can get good ROI out of having a strong privacy program in place, and explaining that in your privacy notice on your website, and maybe even using it in your marketing and advertising. As you know, probably from reading news, there are a lot of privacy-related issues being discussed. Think about what's happening with Google and Facebook and Apple, Amazon, the big companies, and how they're using that data, and the fact that they're being called into Congress into these hearings where they're being asked very pointed questions about how they're using consumer data. If you are a company that builds a strong privacy program, you can use that as a marketing advantage, because consumers especially, if you're a company that's using data and selling it to third parties, or using data and giving free services, for example, like Facebook does, you do have to really think about what the perception of your users and your customers out there are. So if you have a strong privacy program and you can toot your horn about that, that's a marketing advantage. So that's one thing I would say. Secondly, it's important to think about your privacy program as something that is owned by everyone in your company. It's not just, if you're a big company and you actually have a privacy team or a compliance team, great, but they can only guide this. It has to be driven from the top, from the leadership across the company. So business unit leaders should be bought into this, they should be educated, and they should be driving it through their particular business units. One thing I've seen work well is appointing business unit privacy champions across the organization. Those people can be assigned to really help with privacy initiatives within their own business unit and work on a team that's cross-organizational. The other teams that are really important besides just a privacy team to help drive and direct this often include IT, because you're dealing with systems and databases in which the data is collected and stored. Information security obviously is important, and their policies and procedures should be part of the annual training. HR for the employee and applicant data. Legal will often be involved, whether external or internal legal counsel, and then privacy, security, compliance teams. Again, those are the groups that are going to probably be most involved in driving this across the company, but it really needs to be embedded in the particular business units as well. So what can risk and compliance professionals do, those who are driving it? They can conduct risk assessments to see where your business unit or your company as a whole stands with respect to compliance with whatever regulations are applicable to you, but also with just the privacy principles in general that we discussed today. And they can help you put together a strategy and prioritize that to plan over time how you're going to build that privacy program. They can help you create your policies and procedures and communicate that to your staff, and also put together some training.
Yeah, you know, and Julie, one of the things that I've seen over the past few years as companies go after this and really start to get much more serious about privacy, you know, they're used to doing it on the security side. Now they're getting kind of more, you know, experience and understanding the need to do it more on the privacy side, is that, you know, you have a discussion like this where the responsibility starts out and it's kind of striped across different organizations inside the company, and it becomes this kind of, you know, shared responsibility. But then over the course of the last couple of years, what's been going on, maybe the last few years, is there's been, you know, more dedicated folks who are working on, you know, privacy in particular. You know, you have a CISO for security, and then, of course, as organizations get larger and larger, now they have chief privacy officers as well. So that's a phenomenon that's been happening. And it's an interesting kind of segue to the next part of the discussion, which is, you know, right now, I'm sure top of mind for everybody is we know we got to get the privacy stuff done along with the security stuff. We know that in a COVID era, and then also just because of increasing concerns from customers around privacy and some of the, you know, what you see in the press around, you know, Facebook and you know, voter fraud and all these different things, that we have to take this more seriously. But also COVID has put a lot of pressure on budgets, right? So the question is, you know, that with budgets being really tight, you may or may not have the ability to have some full-time staff. What are the options all the way from, I guess, full-timer to not full-timer in terms of how you actually go after, you know, this particular set of challenges?
Excellent question again, Craig. And I think there are a number of options out there for companies to consider, especially as budgets are tight. First of all, just to calm your nerves a little bit, I would say that it's important to remember as you're building these processes and procedures out, you don't need to get it all done tomorrow. I think the best approach is to lay out, you know, some plans, do a risk assessment, figure out what you need to do and prioritize, and then chunk the work out in buckets and take pieces of it on at a time to move toward compliance. As regulators might come and ask you questions, or if they get complaints that they're following up on from their constituents with your company, then if they come in and see that you are working on your program, it may not be complete and perfect yet, but really a privacy program is always a work in progress. So they see that you're making efforts, that you've got the big things checked off and you're continuing to improve. That's going to be something really in your favor. But all that aside, I think you have a couple of options with respect to getting help getting the work done. One is obviously to hire your own privacy team, or maybe to start with one privacy professional who can manage your privacy program internally, be an employee, and work with the different business units to start to build that out. That privacy employee, or if you can't even afford to hire an individual to be an employee in that area, can hire a contract privacy and security consultant. I am a privacy consultant, not necessarily a security consultant, but I work hand in hand with security consultants as needed for my clients. I work with a number of small to mid-sized companies, also large, but I have been successful in helping these smaller companies get their privacy programs started, do the risk assessments, and over time work with them to build these policies and procedures and training and other things that you need up. So I think a contract worker is your second possibility besides employees. And then thirdly, and I'll ask Craig to dive in and talk a little bit more specifically about this, there are a number of privacy technology platform companies, and Hyperproof is one of them, that can help you automate once you get some of your framework in place and you need to actually, let's say, do a personal data inventory across your company and across all your systems. Privacy technology can be very helpful to automate some of that. So Craig, would you like to talk about that?
Yeah, I mean, and I sure would. And I'd break it down into, a couple different areas. I mean, what I see out there in the market is a number of companies that have been innovating in the space around scanning of your data in much the same way that a security vendor would have, been scanning it for for viruses and those kind of signatures. We've got a lot of new companies out there who are doing, work to scan your data to make sure that you don't have PII, personally identifiable information, and other sensitive data, in places where it shouldn't be, and in places where, should you get audited, it would be found to be a violation. So some of those are data, they go by the name of data discovery is the name of that part of the industry, but it's a really interesting part to look into. There's also a number of vendors who do tooling around, helping you get your opt-ins and other things and your privacy policies and those things up on your website, creating really interesting, tool sets around some of those kind of capabilities. I guess, no webinar would be complete without a bit of a shameless plug here. So our company really occupies, I'd say, a third area, which is Hyperproof occupies the area of becoming a system of record for all of your policies, your controls, and really being the single system where you collect the evidence. So from our perspective, we come at this from the concept of continuous compliance. And what we like to say is that up until now in the industry, folks have gotten ready for audits, 2, 3, 4 months before, and they bring all the data together, they send it to the auditor, they get through it, and then they kind of take a break, and then they do the same thing the next year, the next year, the next year. And I think that kind of situation worked when you only had to deal with maybe one security program. But, in today's world where you've got 4 or 5 security programs, a couple of privacy programs, et cetera, you really have to maintain a more continuous stance. And so at Hyperproof, what we do is we're the system of record for all of your controls, for your compliance programs. All of your evidence goes into Hyperproof. You can run your audits out of Hyperproof. And the key benefits are that you maintain your compliance state through the course of the year, very much the same way that your company wants to maintain security through the course of the year. You can maintain your compliance state, and it reduces the risk profile quite a lot. The other the other big benefit of it is that it takes a lot less effort to get through each of these audits because you've got all the information collected and ready at the right time. So that's kind of what we do here at Hyperproof. We'd love to chat with you if you guys want to take a look at what we're doing. The one thing that I do want to talk through here is that at the very beginning, I think it was back in March of the COVID crisis, we set up a couple of free offers to get folks involved with the program at a time where, to our previous discussion, budgets didn't really allow it. And we actually ended up, interestingly, focusing on exactly the programs that we spoke most about during this conversation. So CCPA and GDPR are 2 programs that you can run fully end-to-end out of Hyperproof, and we made those free for the period of time while we're tackling, COVID. And so it started in March. It's ongoing now. It's a great way to get involved with Hyperproof should you have the interest. So thanks for that segue, Julie, and for asking me that question. So I think at this stage, for all of you folks who are watching and listening, we are done with the prepared content, and I think we're ready to kind of transition back to JC to any questions that folks have answered, and we can close it up with a little bit of Q&A.
And excuse me, Craig, could I ask you one more question related to Hyperproof and your product? Do you recommend that companies, in addition to using your technology, work with their internal privacy team or an external consultant to get the privacy program built and to collect and put that evidence, that good evidence, in your system?
Yeah, that's a great question, and it's actually timely. There are folks out there who will say, hey, technology, it's going to, technology's eating the world, right? It's going to replace everything. And let me just be really, really clear on this point. And I'm going to bet you're going to agree with this, Julie, which is that this is an area that no amount of, artificial intelligence at this point is going to get you through without having the trusted advice of experts. And that comes in many forms. If you're working with Hyperproof, we have a customer success team that can get you up and going on the software, but we always recommend that you either have a team of experts on security and privacy in particular inside your organization, or you work with a partner of ours or a partner of your own, somebody who can actually bring in that expertise and both kind of give you a bit of an objective view as to how you're actually setting up your program. A lot of these programs, security and privacy, you have a lot of degrees of freedom to set it up the way you want, but when it actually comes time to get audited, there are kind of industry standards that you need to, make sure you comply with. It's not fully up to you. So having those kind of folks who can tell you what is the best practice in the industry, especially as it evolves and changes, is absolutely crucial. And as you pointed out, Julie, if you're a big enough company, you'll start off by hiring folks. Typically, you start off in security and then you extend to privacy. Depending upon the kind of company you are, you could go the other way. But if you don't have that expertise in-house, please, for everybody involved, for the company, for your stakeholders, and for your customers, and everybody involved, please do involve somebody that has that expertise.
Thank you, Craig.
Okay. Yeah, no, great question. Thanks, Julie. JC, have some questions?
Yeah, so we have one question, and this was in the section where you were covering contact tracing and the different considerations there. The question is regarding software used for proximity monitoring. Could personal...
Whoops, JC, I think we lost you there. You see, at proximity monitoring.
So the question is for proximity monitoring. Could personal de-identification be a possible solution to keep personal information private?
I'll take that, Craig. Absolutely. That
yeah,
is a great point to bring up.
Yes.
Right. Yes. If you must collect this information, if it's the best fit for your company, and you're able to use a technology that de-identifies the personal information or who you're tracking or that kind of thing, that is very, very helpful. And again, you'd want to mention that in your privacy notice explaining how you're using it and the fact that it will be de-identified information.
Thank you. Next question. U.S. and EU have different histories regarding litigation. How would a company prove they did what they could to keep employees' information safe if this information isn't collected?
I need a little bit of clarification on that. If the information about the employees, no personal information is collected, is that, how you interpret that, JC?
Yeah, I think we would love some clarification from April, who asked this question. April, if you're still on the line.
I'm going to guess. I have a guess at it, which is if the last word was retained. I think the question is around if you don't retain the data, how could you litigate to show that how could you prove that what is no longer there, is my guess as to what this question is asking.
Right, and if that's what April means, I would say if you have policies and procedures in place and you can demonstrate that you do not retain the data or you have securely deleted it, and here's your documented procedure for doing that, that will probably be what a regulator is looking at, or, if it gets to litigation, that would be evidence that you could provide.
Super, super. Okay. Excellent. JC, any other questions?
Let's see. We'll wait a moment because there's sometimes a lag between people entering their questions and showing up on the panel here. Looks like we don't have other questions, so we can wrap up over here and give people time back in their day.
Well, great. Well, thanks everybody for attending today's webinar. Julie, thank you very, very much. I found it absolutely fascinating. I personally learned a lot hearing you speak. Apologies for getting going, for the technical difficulties and getting going a few minutes later. JC, I want to thank you for hosting it for us, and we'll sign off now, give everybody a few minutes back, and we'll see you next time in our webinar series in Hyperproof.
Thank you, and JC, you will be posting these slides that have our websites if you want to contact us, correct?
Yeah, that's
correct.
Right. So everybody, you turn to the resources section, you should be able, the speakers panel in your view, you should be able to see Craig and Julie. I have provided links to their email and their LinkedIn as well, so that we can, if you want to, you can reach out to them. There's also another link to the free software subscription offer that is posted. You should be able to see it there. And lastly, we are recording this webinar, and you shall receive via email a link to the recording shortly.
Thank you, JC. Thank you, Craig.
Wonderful. Yes, thanks everybody again, and we'll see you next time. Bye-bye.
Thanks. Bye-bye.
Bye.